A casual trip to a gun range can turn into a serious legal problem fast. If you have a felony conviction and your firearm rights have not been fully restored, the safest answer is simple: do not shoot at a range. Do not rent, handle, or possess a gun or ammunition there. Maybe a friend invited you. Maybe it seems harmless. Maybe you're thinking, I'm not buying a gun, I just want to shoot for an hour. That is exactly where people can get into trouble. The risk is not only owning a gun, the risk can be touching one, renting one, loading ammo, or being in a situation where the law says you had possession or control. This is general educational information, not legal advice. Your answer depends on your record, your state, and your paperwork. It also depends on whether you're under supervision, release conditions, or bond. And one detail matters a lot. Finishing your sentence does not always mean your gun rights came back. Here's the short answer. Under federal law, often referred to as Section 922, subsection G, many people convicted of a crime punishable by more than 1 year in prison are prohibited from possessing firearms or ammunition. Some convictions may be affected by a pardon, expungement, set aside, or restoration of civil rights. But if you are still legally prohibited, a gun range does not create a special exception. So if you are prohibited, do not rent a gun. Do not shoot a friend's gun. Do not handle a firearm just for a second. Do not load magazines or hold ammunition. Do not assume it is safe because you are not buying anything. The gun does not have to belong to you for possession risk to exist. A range rental can still be a firearm in your hands. A friend's gun can still be a firearm in your hands. Range ammo can still be ammunition you possessed, so the key question is not, did I own it? The key question is, did I possess it? This is where I was only borrowing it can become a dangerous assumption. In plain English, possession can mean more than ownership. Federal jury instructions describe different forms in firearm cases. Those forms include actual possession, constructive possession, sole possession, and joint possession. Actual possession is the easy example. A gun is in your hand, ammo is in your pocket, you're loading a magazine. Constructive possession is more complicated. It can involve control, access, and the facts around the situation. So picture common range situations. You rent a gun from the counter and shoot it. Your friend hands you a pistol in the lane. You load ammunition into a magazine. You share a shooting bench where guns and ammo are right there. If you are a prohibited person, none of those situations should be treated as casual or harmless. Temporary handling is not automatically safe. The fact that the range owns the gun is not a reliable defense. The fact that your friend paid for the lane does not magically protect you. The law cares about possession, not just purchase, and the penalties can be serious. A knowing violation of the federal prohibited person firearm law can carry a fine, prison time up to 15 years, or both under Title 18, United States Code, Section 924. That is too much risk for one outing. Now let's talk about supervision, state rules, and restoration. Supervision terms can be stricter than the basic federal rule. That includes probation, parole, and supervised release. It can also include bond conditions and court orders. Your paperwork might restrict being around firearms. It might restrict associating with people who carry weapons. It might restrict entering places where firearms are present. That means I was just watching may still be a problem. State law can also create separate rules. The range may have its own policies too, and range employees are not your lawyer. If you have a supervising officer, ask before going near gun ranges or gun shops. Ask before hunting trips or shooting outings. Be specific. Ask if you can enter a gun range as a visitor. Ask if being around guns violates your terms. Ask if riding with someone who has firearms creates a problem. Gun rights restoration is another place where people get confused. Federal law says some convictions may not count for firearm disability purposes after expungement, set aside, pardon, or restoration of civil rights. That exception fails if restoration still restricts firearms under Title 18, United States Code, Section 921. That last part matters. The paperwork must actually remove firearm restrictions. Restoring some civil rights does not always restore gun rights. A nonviolent felony is not automatically safe. Finishing probation or parole does not automatically restore firearm rights everywhere. An expungement does not always mean you can possess a gun. ATF also explains that people with disabling convictions may need specific relief. That may mean pardon, expungement, set aside, or restoration of civil rights depending on the case and the type of conviction. So pull your judgment, sentencing paperwork, supervision terms, and any restoration documents. Check federal law, check your state law, and check the law where the range is located. Talk to a qualified criminal defense or firearm rights attorney. Until your status is confirmed, decline shooting invitations. Do not handle guns, ammunition, or magazines. Avoid cases and rental equipment. So, can a felon go to a gun range? If you are still legally prohibited from possessing firearms or ammunition, do not shoot or rent at a range. Do not handle or possess guns or ammo there. Simply being present is a separate question, but it can still create problems under range rules or state law. It can also violate probation, parole, supervised release, or bond conditions. Protecting your freedom and stability matters more than one outing. Confirm your legal status first, get it checked against your actual paperwork, and if possible, get clear guidance in writing before going anywhere near firearms. If this helped, like this video, subscribe to Fresh Start Society, and visit freshstartsociety.hq.com for more information.